Friends, in this video I am going to discuss the conflict between the fundamental rights which are guaranteed to the individuals by the Constitution and the privileges and immunities guaranteed to the members of legislative houses. These privileges are provided to the members to enable them to discharge their duties without any obstruction, fear or favor. There are several instances wherein the courts had to consider the conflict between the parliamentary privileges and fundamental rights and had to decide which will prevail over another in a case of conflict between the two. The first case this issue was considered was in Gunapati Keshavaram Reddy versus Nafishul Hassan in 1954. In this case, Blitz, an English tabloid, published a news item casting derogatory aspersions on the Speaker of the UP Legislative Assembly. The Committee of Privileges summoned Home Ministry, the editor, to appear before it to offer his explanation. Ministry neither appeared nor sent any reply. The Speaker issued an arrest warrant against Ministry on the basis of a resolution passed by the House for the breach of privilege. Home Ministry, that is the editor, was arrested at his Bombay residence under the warrant issued by the Speaker and was flown to Lucknow and kept in a hotel in Speaker's custody. He was kept in the hotel for several days without doing anything in the matter. In the meantime, a petition for a writ of habeas corpus was filed by the editor on the ground that his detention was in violation of his fundamental right, as he was not produced before the magistrate within 24 hours of his arrest under Article 22, Clause 2. The Supreme Court accepted his contention and quashed the detention and ordered his release on the ground of a violation of his right under Article 22, Clause 2. This decision created the impression that the fundamental rights would prevail over the parliamentary privileges in a case of a conflict between them. However, in MSM Sharma versus S.K. Sinha, popularly known as a Searchlight case, decided in 1959, the Supreme Court held that the privileges of a House of Parliament under Article 105, Clause 3 and state legislatures under Article 194 were not subject to Article 19(1)(a). In this case, a member of the Bihar legislature made a speech on the floor of the House which was ordered by the Speaker to be expunged. The Searchlight, that is the newspaper, published the entire speech in defense of the Speaker's order. The editor was accused of a breach of privilege of the House and the matter was referred to the Committee of Privileges. The committee summoned the editor to answer the charge of a breach of privilege. The editor, instead of appearing before the committee, moved a writ petition before the Supreme Court under Article 32, contending that the proposed action of the committee violated his fundamental right under Article 19(1)(a), which guarantees the freedom of speech and expression. It was also contended by the petitioner that the privileges of the House under Article 194, Clause 3 are subject to the fundamental rights in Part 3 of the Constitution. In support of his contention, the petitioner relied on the Supreme Court's decision in Gunapati Keshavaram Reddy versus Nafishul Hassan, which we just a while ago referred. But in this case, the Supreme Court held that in case of conflict between fundamental right under Article 19(1)(a) and a privilege under Article 194, Clause 3, the latter would prevail. As regards Article 21, on facts of the case, the court did not find any violation of it. Chief Justice Das, who delivered the majority judgment, observed that the House of Commons had, at the time of the commencement of our Constitution, the power of privilege of prohibiting the publication of even a true and faithful report of the debates or proceedings that took place within the House. If fortiori the House had at the relevant time the power or privilege of prohibiting the publication of an inaccurate version of such debates or proceedings. The court said that the effect in law of the order of the Speaker to expunge a portion of the speech of member might be as if that portion had not been spoken. In re under Article 143, a reference case, the Supreme Court explained the proposition laid down in the MSM Sharma case and said, I quote, "We do not think it would be right to read the majority decision as laying down a general proposition that whenever there is a conflict between the provisions of the latter part of Article 194.3 and any of the provisions of the fundamental rights guaranteed by Part 3, the latter must always yield to the former. The majority decision, therefore, is taken to have settled only that Article 19(1)(a) would not apply and Article 21 would." Unquote. The conflict between legislative privileges and the law courts came to be resolved by the Supreme Court in a re under Article 143, which is a reference case which is popularly known as Keshav Singh's case. Keshav Singh, a resident of Gorakhpur in UP, had published pamphlets containing some defamatory statements against a sitting MLA of the ruling party. It was considered as an issue of breach of privilege of the member. Keshav Singh was summoned by the Speaker to reprimand him. Keshav Singh presented himself before the House, and when he was reprimanded by the Speaker, he showed total contempt for the Speaker. The Speaker regretted the attitude of Keshav Singh and sentenced him to simple imprisonment of 7 days. He was sent to jail in Lucknow. While hardly 2 days left for his release, Mr. Solomon, his advocate, moved under Section 491 CRPC read with Article 226 a habeas corpus petition before the Lucknow High Court alleging that Keshav Singh's detention in jail was illegal and mala fide because he was not given an opportunity to defend himself. The petition was heard by 2 judges of Allahabad High Court, which granted interim bail to Keshav Singh and he was released pending the decision of the case on merit. On this, the Assembly, which was infuriated by the intervention of the court, by a resolution took the view that the 2 judges, the petitioner, Mr. Keshav Singh, and Mr. Solomon, his advocate, had committed contempt of the Assembly and ordered that the Keshav Singh be immediately taken into custody and the 2 judges and advocate be brought in custody before the House. So this situation is an unprecedented situation in the annals of the constitutional history. At this, the 2 judges and the advocate by separate petitions moved the High Court under Article 226 and contended that the resolution amounted to contempt of court and that it be set aside and its implementation be stayed by the interim order. In an unprecedented move, the petition was heard by the full bench of all the 28 judges of the Allahabad High Court. The court ordered the stay of implementation of the resolution. Then the Assembly relented and modified its order and the warrant issued against the 2 judges was withdrawn, but they were asked to appear before the House and explain their conduct. The judges moved an application before the court against the modified order and the court granted the stay against the implementation of the latter order. At this stage, the President of India referred the matter to the Supreme Court, invoking the provisions of Article 143, Clause 1 for obtaining its advisory opinion to clarify things. The main questions referred to the court the court were whether the legislature is the sole and exclusive judge of its privileges and whether it is competent to punish a person for its contempt taking place outside the legislature. Secondly, the second issue that was referred was whether the High Court, who entertained a petition of habeas corpus challenging the validity of the detention of a person sentenced by the Assembly under a general or unspeaking warrant, has committed contempt of the legislature. The Supreme Court, by a majority of 6:1, held that the two judges did not commit the contempt of the House by issuing an interim bail order. The court explained that the court under Article 226 had jurisdiction to order the release of a person from illegal detention. The court said that the courts in India would examine the validity of detention of a person sentenced by the Assembly or by the House of the Parliament under a general or unspeaking warrant. The courts in England cannot examine the validity of the general warrant issued by the House of Commons. Referring to this, the court said that such a right was not conferred on the legislatures in India. The House of Commons is a part of the High Court of Parliament. As a superior court and as a result, the general warrant issued by it cannot be subjected to the scrutiny by the other superior courts. Legislatures in India never discharge any judicial functions, and their historical and constitutional background does not support the claim to be regarded as a court of record. Therefore, the very basis on which the court in England treats a general warrant issued by the House of Commons is absent in India. Article 226 confers wide power, according to the court, on the High Court to issue the writ of habeas corpus against any authority which under Article 12 included the legislature. Article 121 prohibits any discussion in a state legislature on the conduct of any judge of the Supreme Court or High Court in the discharge of his duties. The court further opined that it could not be disputed that in the matters of privileges, the House was the sole and exclusive judge provided such privilege could be found in Article 194, Clause 3. The question whether a privilege as claimed by the House was provided by Article 194, Clause 3 or not was a matter for the court to decide. The nature and scope of Article 194, Clause 3 was thus to be determined by the court. The question whether the privileges enjoyed by the legislature under the latter part of Article 194.3 were subject to the provisions of Part 3 relating to fundamental rights was left undiscussed. However, the court observed that such privileges were necessarily subject to Article 21 and 22 of the Constitution. In view of the above analysis, it could be concluded that in India, whatever privileges are available, they are derived from the Constitution. There is no custom or separate law as in dealing with the privileges. Privileges are limited to certain immunities and the autonomy of the House to manage its own internal affairs. In any disputed case, the court has to decide whether a privilege exists or not, whether a particular conduct amounts to contempt or not. Once this is determined, it is for the House to decide whether a breach has occurred or not. Further, if any authority does not exercise its powers properly, in accordance with the provisions of the Constitution, the court can always step in. With this, I conclude this presentation. Thank you.